Why I am in US court against Tinubu, Atiku says. Welcome to the news and thank you for tuning in to listen. Please subscribe to our channel. Former Vice President Atiku Abubakar has said that he is on court in the United States against President Bola Tinubu in order to further the cause of democracy in Nigeria. At the United States District Court of Illinois, Atiku's lawyer Angelo M. Liu late on Wednesday filed the former vice president opposition to Tinubu's objection to an earlier order for his Tinubu's Chicago State University CS records to be released. The lawyer said in the pleading that Atiku is not seeking the disclosure of intervenors Tinubu's educational document. He is seeking to authenticate documents that are already in the public record. A decision of the court is expected shortly. Speaking with Saturday Tribune on Friday, Atiku spokesman Frank Shaibu said everything the former vice president was doing in the case was to strengthen democracy. Our expectation is that the United States Court will render justice. We have been able to show that our need for the record of discovery as extra evidence in our appeal at the Supreme Court far outweighs Tinubu's claim to the preservation of his so-called right to privacy. Our country and our democracy will be better for it by unveiling the records of Tinubu as the CSU, he said. PDP speaks. Meanwhile, the People's Democratic Party, PDP, has said that the application by the lawyers of President Bola Tinubu urging the United States District Court of Illinois not to release details of its academic records at the Chicago State University are in direct conflict with his public declarations that our records impeccable. The main opposition party has therefore charged the All Progressive Congress APC to come clean on what is said is desperation by the lawyers to conceal certain vital details regarding the president's academic records. The PDP made the assertion in a statement issued on Friday by Debo Ologunagba. It is called National Publicity Secretary, where it recalled the president Tinubu had in a public function openly asserted to Nigerians that I was one of those most recruited graduates of my university multiple honors, first class degree, and I have the reference point. The statement noted that in view of the above assertion, the plea by the lawyers that the details of his academic record should be released, it is a great disservice to President Tinubu in particular and Nigeria in general. The desperation to conceal vital information is consistent and with APC penchant. And with APC penchant for trickery and underhand dealings in their transactions with Nigerians, which has heightened up under Abdullahi Gandiji leadership. As an emergency hearing last week, Judge of the District Court of Northern Illinois, Eastern Division Judge Nancy Maldonado has agreed with Tinubu to delay an earlier order by a magistrate court to delay APC penchant for trickery and underhand dealings in their transactions with Nigerians, which has heightened under the Abdullahi Gandiji leadership. At this emergency hearing last week, the judge of the District Court of Northern Illinois, Eastern Division Judge Nancy Maldonado has agreed with Tinubu to delay an earlier order by a magistrate court which directed Chicago State University to provide academic documents of President Tinubu within 48 hours. Maldonado ordered the lawyers on both sides to file additional argument by Thursday, 28 September. Ms. Donald says she would as quickly as possible after the filing, saying, I will have a busy weekend. The issue of process and rules. I am a rule person and that is why I'm a judge. The case is quite involved. I am aware of the stakes. It's more important to me to get this right. She was quoted as making that statement by CBS News. Atiku had alleged that documents showing the Tinubu graduated from Chicago State University in 1977 a profit. In 1979, we are fraught rather with inconsistencies. The university wasn't the case when it told the court that it would confirm the president graduated from CSU but could not authenticate the certificate in question because it is a ceremonial document that was not part of a student's official academic life. At the hearing by the United States District Judge last week Thursday, Chicago State University lawyer Michael Hayes said the university was ready to provide the requested documents once the legal issue were resolved. We do not have a dog in this fight, said Mr. Hayes, adding that the university had amassed significant legal fees and had unwarranted bad public relations because of a political fight in the foreign land. Article requests are that the university should be compelled to provide the following. 1. An example of Chicago State University diploma issued to President Tinubu in 1979. 2. Mr. Tinubu's diploma issued in 1979. 3. Any example of a Chicago State University diploma that enters the same font, seal, signatures, and wording as contained in Exhibit C to the First Law Declaration, which purports to be a CSU diploma issued to Mr. Tinubu on the 1st June 1979. 4. CSU documents certified and produced by Jamal Orr, an Associate General at Ansel at CSU. Judge Jeffrey Gilbert of a magistrate court in Chicago had earlier issued a 48-hour ultimatum to the CSU release Tinubu's academic record to Atiku to enable him prove his case against Judge Jeffrey Gilbert of a magistrate court in Chicago had earlier issued a 48-hour ultimatum to the CSU release Tinubu's academic records to Atiku to enable him prove his past against the nude at the Presidential Election Tribunal. Judge Gilbert noted that the court may, for good cause, issue an order protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Alright, she added that for all of the reasons discussed above, Atiku Abubakar's application pursuant to 28 U.S.C. and 1782 for an order directing discovery from Chicago State University for use in the foreign presidency ECF number is granted. The court shall further hold the institution shall produce all relevant and non-privileged documents in a response to quest by Productions Number 1 through as narrowed by the court in applicant's subpoena within 2 days of the entry of this memorandum opinion and order. Wow. Okay, on this note, you have come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy.